a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater 8 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon.
At first, this sounded like a simple request. The defendant charged with manslaughter asked Judge Raquel West for permission to drive again while awaiting trial. But once the court started reviewing his driving history, the conversation took a very different turn. Previous crashes, speeding violations, and serious concerns about public safety suddenly became the center of attention. The defense argued that he needed to drive to work and live a normal life.
Oh, it's lots of pages. All right, let me hold this for a minute so I can go through that. I did not see it. I said, no, you did. Well, I can't use this. I need, if they're going to do a response, I need it before. No, it's not you being sorry. I don't need to. This is Mr. Coleman's case?
Yes, sir.
Are you prepared to argue?
Yes, sir.
Okay, I'm not gonna, I mean, this was filed this morning, so I'm not gonna take. Come on back up. Let's just do it. All right, so you're Larry Fletcher Jr.
Yes, sir.
And this is cause numbers 25 DCCR 0838 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon and manslaughter. There's a motion that has been filed to modify the conditions of bond. That he cannot operate a motor vehicle. And so, Mr. Gertz, go ahead.
Judge, I think you're familiar with the facts of this case because we had a hearing on a motion to revoke probation. And the issue in that hearing was about causation of the accident. And the court decided that the issue was serious enough to hold that in abeyance pending trial on these two cases. And my request here is based on the fact that Mr. Fletcher has been following all of these bond conditions, following the rules the court set, but is having difficulty getting to and from work and doing other things that he needs to be doing to be a productive member of society. And he's not allowed to drive. And so, this was not an alcohol, like it's not an intoxication manslaughter case. It's just a manslaughter. It's just an allegation of reckless driving.
The problem is the history of reckless driving. And so what the state has provided, it looks like, is that there was a 2010 non-injury crash, 2012 non-injury crash, a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater than 15 miles over, 2018 a non-injury crash, 2021 a non-injury crash. Based on my knowledge, what was presented at that hearing, regardless of causation, there was definitely a speeding issue. That was clear from the black box in the testimony, that there was a large speeding issue. And so I am not inclined to change the bond. Mr. Nichols, does this?
That was the basis of the state's argument, Your Honor, was that his history of crashes and of speeding poses a danger to the public, and that's why we were opposed to altering these conditions.
Yeah.
Judge, we were just alerted to all of that at the same time the court was, that was filed Friday afternoon at 4 o'clock. So.
Well, it is what it is. If there's something in there that you find that is not accurate, then just let me know, file a supplemental motion. But at this time, I'm going to do the motion to modify the bond and conditions. We'll get it set. It's already on the trial docket.
It is, Judge.
All right, but it'll go back right on the trial docket. And again, if there's something that's changed that's not correct, let me know.
Okay, and I think Mr. Coleman has filed a supplemental motion to revoke probation too, which will have to be heard at some point because we're going to plead contrary to that as well.
We'll go over any motion to revoke after.
He may not have filed it yet. He may have just told me he was going to file it. But.
So. That the only two cases are on here are the trial cases, not the motion to revoke cases on our docket, correct?
Yes.
Okay. All right, if something comes through that I need to hear, but my thought is still to go forward with the trials first and then to deal with the probation,
I understand.
unless there's something else significant, another new case or something.
I'm not aware of anything, Your Honor.
Okay.
Well, and let me back up and say, it's not a new case. In the wake of the motion of a probation hearing, Mr. Coleman filed a federal case relating to the
The gun that
other
was
stuff.
found?
Yeah.
Okay,
So and he's not a convicted felon, but we'll argue that when it's time to argue that. But that's what the new case is.
okay. That was something that I've already heard in that motion to revoke to some extent.
Correct. Yeah.
Okay, all right. We'll see you back at the trial date then. Good morning, sir. You're Brian Battle. Good. And Mr. Battle was previously here in court, entered a plea of guilty in clause number 25 DCCRs 1050 to evading arrest or detention with a motor vehicle. I received that pre-sentence report. Has everyone had an opportunity to review it?
Yes, Your Honor.
I have, Judge.
Are there any additions or corrections?
None from the defense, Your Honor.
Judge, only I would like the court to
No, on the defendant's behalf, he is a veteran. He's
I
already
have
plugged
that
in
note.
with
I've already.
with the
Sorry.
VA. He's already working with them, so I
Good.
wanted to invite him to either come and observe our docket on June 17th, or if it would be okay with him, I will have Ms. Lowe reach out once he gets established on probation. Let him know what we have and we can help him with from that end, maybe
Yes.
even to get his probation. I would certainly agree to an early termination if the court would, if he successfully completes that after 2 years. I want to make it
Right.
available to him, but
So
I don't
there's a
want-
veteran court program. That's a great program. That's what Ms. Molfino is talking about. And so you can go through that program while you're on probation, and it can help you with everything that has to do with your veteran stuff, in addition to what you're already doing, and it can help you get off probation early as well. So it's definitely something. Ms. Holmes can get that date and get you signed to go at least look, but I would strongly suggest you go through that program. It's a great program.
Yes, ma'am.
Okay, good. So, I'm sorry.
I'm about to say, I didn't know nothing about it. They don't really tell us this thing.
Right, and it's something that kind of happens up here, and as soon as I saw, some that your duty and what's gone on with you, and that I made a notation of veteran court on here, so it's a great program. So I'm going to find Mr. Battle that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity. You won't have a felony conviction on your record. And at the end of your probation, the case will actually be dismissed. You'll never have the conviction. The other side of that, however, is if you violate any condition of probation, then you could be back in court, found guilty of the offense and sent to prison anywhere in that punishment range, which is between 2 years and up to 10 years in prison. So it's, again, get that information from Ms. Holmes and Ms. Malfino before you leave today. And that way you can go to that first, the one that's coming up pretty soon, and hopefully get signed up and go through that program as well. All right. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over all your paperwork. All right, good luck to you, sir.
Yes, ma'am. Thank you.
500.
Yes, ma'am.
All right, ma'am, your Trinity Bell. And this is cause number 25 DCCR 1381. I'm going to reset, just a normal reset to give you guys time to get it filed down in misdemeanor court, get that taken care of. If everything gets taken care of and you go to court down there, then you probably won't have to come back to this court date. Your case will be dismissed. Unless you hear otherwise, though, plan on being back here unless Ms. Holmes or your bondsman tells you you don't have to, okay?
Yes.
All right.
And
Thank
we
you.
had one, Ms. Bell has been wearing a GPS ankle monitor for quite some time, and we were wondering if the court would allow her to have it removed, or.
Let me look real quick. I don't know that I have any notes on any issues.
Who's your prosecutor down?
Mr. Smith.
Judge, we're not opposed to it.
All right, so Ms. Bell, I'm going to remove that condition of your bond that you have to have. Well, actually, let me make sure first that it's a condition of the bond and not the bondsman.
Oh.
Because if it's their condition, that's up to them. If it was the court's condition, I can change it. And I forget to look at that sometimes and they get very mad at me.
Indifferent is fine.
Let's see if I can figure this out.
What we would do is probably just get a post on those and then just mix this. I mean, they don't really do it, since I'm we can just ask for a poster. It's a short and sweet person, that's it. Yeah, letter.
I don't see that I don't see it notated on the magistrate's warnings.
What price to the judge?
Yeah. Okay,
Yeah. Still.
there we go. Right there where it says bonds.
It is.
It's there, it's mine. It's a court bond. Okay, so then, our court condition. Have you been going to, did you go get an assessment? Have you been going to Spindletop like you were supposed to?
No, ma'am, I lost my job, so I don't have any insurance coverage anymore.
Well, that's the nice thing about Spindletop is you don't have to have it.
Okay. Well, I did make an appointment for it.
Okay, so that was also a condition of your bond,
Okay.
that was set. And so it's very important that you still follow through with that. So even if it's gonna be misdemeanor case, you need to go get that assessment done, call and make your appointment so that you can get that done before they'll take care of that other stuff, okay?
Okay.
But I will remove the GPS monitoring device condition today. Ms. Holmes can tell you, y'all can talk about how to do the Spindletop thing, but I'll remove the bond condition of the GPS device today. All
Okay.
right?
Okay,
Okay,
thank
stay in
you.
touch with Ms. Holmes.
Yes.
Good morning. Are you Aston Hayward? And will your client make the formal reading of the indictment?
Yes.
Sir, what?
Class A attempted.
Attempted. Right, Mr. Hayward, in cause number 25 DCCR 1346, the state has elected to proceed on the lesser included offense of a Class A misdemeanor attempted burglary of a building from August 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,620. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to follow all of the rules and conditions of probation, and you're ordered to pay that restitution in the amount of $2,620. If you do everything that you're supposed to on this probation, get the restitution paid off, this is a great opportunity because you don't have a conviction on your record. And if you satisfactorily complete the probation, at the end, the case gets dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of your probation, then you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand? So $2,600 is a lot to pay in 2 years. How old are you? 8. So you're very young. It's very important that you make payments on that every single month, even if it's a little bit, because it'll add up. All right. So some people think, well, I'm going to get a better job, or I'll sell this, or I'll get my tax refund and I'm going to wait to pay it. and then all of a sudden you're at the end of your probation and you haven't paid it. If you come back at the end of your probation, you can have done everything else right and not paid that money. And if I find that you could have paid it, then you could still be revoked and go to jail even after 2 years. Do you understand?
Yes, ma'am.
Also want at least half of whatever he pays to go to restitution in the beginning. Okay, so that way I want them to get paid, the victim to get their money and get paid for what happened. Okay, that's very important to me. So I'm going to hand you now the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation is sitting at that desk right there. She's going to call you up to her desk when she's ready to go over your paperwork.
This hearing
All right,
focused
good luck
on
to you,
Larry
sir.
Fletcher
Thank you.
Jr., who is facing manslaughter and aggravated assault charges, and asked the court to remove a bond condition that prevented him from driving. His defense argued that he had been following all bond conditions, needed transportation for work, and that the case did not involve intoxication. They asked Judge Raquel West to give him the opportunity to drive while awaiting trial. However, prosecutors pointed to a long history of speeding violations and multiple traffic crashes, arguing that allowing him to drive again could pose a risk to the public. After reviewing the information presented by both sides, Judge Raquel West concluded that the concerns about public safety outweighed the defendant's request and denied the motion to modify the bond conditions. The ruling means Fletcher remains prohibited from driving while the criminal case moves toward trial. While the final outcome of the manslaughter case has yet to be determined, this hearing showed how courts often balance individual freedoms against community safety when making pretrial decisions. If you found this case as interesting as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns, legal stories, and real-life cases. Thanks for watching.